Hello, everyone, and welcome to Internet Law Review. For today's story, we have the state of Washington versus Cougar Den. I think we can all agree that this is a fairly great case name, and what this case involves is an Indian reservation, or more properly, people who belong to an Indian reservation who were conducting business, and the question at bar here is whether that business can be taxed under state law. Indian reservations and their populations are governed by federal law, and there are issues dealing with state law in terms of when they can and cannot be taxed, and this is simply such a case. Whether or not particular fees that would normally be due to a normal person are also applicable to the Indian tribe and their citizens. So let's read the fairly fun named case of Washington v. Cougar Den and see what the Supreme Court says the issues are and how they're to be resolved. So let's get started. The state of Washington taxes motor vehicle fuel importers who bring large quantity of fuels into the states by ground transportation. Respondent Cougar Den, a wholesale fuel importer owned by a member of the Yakama Nation, imports fuel from Oregon over Washington's public highways to the Yakama Reservation to sell to Yakama-owned retail gas stations located within the reservation. In 2013, the Washington State Department of Licensing assessed Cougar Den $3.6 million in taxes, penalties, and licensing fees for importing motor vehicle fuel into the state. Cougar Den appealed, arguing that the Washington tax, as applied to its activities, is preempted by an 1855 treaty between the United States and the Yakama Nation that, among other things, reserves to Yakama the right in common with the citizens of the United States to travel upon all public highways. I just have to say, as a partial aside, when I see something about the right to travel upon public highways, my sovereign citizen button is pushed in a very, very hard way. Because normally when you're talking about right to travel, all kinds of soft sit things come to mind, so just immediately gets a laugh out of me, but let's get back to the facts at hand. A Washington Superior Court held that the tax was preempted, in other words, that they can't charge the tax, and the Washington Supreme Court affirmed. Held, the judgment is affirmed. Justice Breyer, Sotomayor, and Kagan wrote that the 1855 treaty between the United States and the Yakama Nation preempts the state of Washington's fuel tax as applied to the Cougar Den's importation of fuel by the public highway. The Washington statute at issue here taxes the importation of fuel by public highway. The Washington Supreme Court construed that statute in the decision below. That court wrote that the statute taxes the importation of fuel, which is the transportation of fuel. It added that travel on public highways is directly at issue because the tax is an importation tax. The incident of a tax is a question of state law, and this court is bound by the Washington Supreme Court's interpretation of its own state law. Nor is there any reason to doubt that the Washington Supreme Court meant what it said when it interpreted the statute. In the statute's own words, Washington, that is the state, imposes upon motor vehicle fuel licenses, including license importation, a tax for each gallon of motor vehicle fuel that enters into the state, but only if entry is by means of a rail car, trailer, truck, or other equipment suitable for ground transportation. Thus, Cougar Den owed the tax because Cougar Den traveled with the fuel by public highway. The state of Washington's application of the tax to Cougar Den's importation of the fuel is preempted by the Yakama Nation's reservation of the right in common with the citizens of the United States to travel upon all public highways. This conclusion rests upon three considerations taken together. First, this court has considered this treaty 4 times previously. Each time it has considered the language very similar to the language now before the court, and each time it has stressed that the language of the treaty should be understood as bearing the meaning that the Yakamas understood it to have in 1855. Thus, although the words "in common with" on their face could be read to permit application of Yakamas of general legislation, like the legislation issue here that applies to all citizens, this court has refused to read "in common with" in this way because that was not what the Yakamas understood the words to mean in 1855. So in generally, this is a good reminder that words mean what they meant when the words were written, because words change over time. And when we're trying to interpret statutes or trying to interpret constitutional provisions, we look to how the usage of the words was at the time, because when people pass laws or they do other actions, they understand them as it's understood at that time, which makes fairly obvious sense. So as language evolves, the meaning of the statute doesn't also evolve because the statute was fixed at the time the president signed it or the amendment became ratified or otherwise became operative. So when we're looking at a text like in common with, we have to look to what the people understood it to mean at the time in 1855. So whatever meaning those words might have today is irrelevant because we're looking to the statutory intent of the people who agreed upon this language. Let's continue with what the court had to say. Second, the historical record adopted by the agency and the courts below indicates that treaty negotiations and United States representative statements to the Yakima would have led the Yakimas to understand that the treaty's protection of the right to travel on public highways included the right to travel with goods for purposes of trade. Third, to impose a tax upon traveling with certain goods burdens that travel. And the right to travel on public highways without such a burden is just what the treaty protects. Therefore, precedent tells us that the tax must be preempted. In a prior case, for example, the fishing rights reserved to the Yakimas in a treaty was held to be preempted by the application to the Yakimas of state law requiring fishermen to buy a fishing license. The court held that such extraction of a fee as a prerequisite to the enjoyment of a right reserved in the treaty cannot be reconciled with a fair construction of the treaty. If the cost of a fishing license interferes with the right to fish, so must a tax imposed on travel with goods, here fuel, interfere with the right to travel. So I think this is also a fun example that federal cases and cases in general sometimes are over fairly small stuff. Maybe you would say they're over small fish. Justice Breyer announced the judgment of the court and delivered an opinion, in which Sotomayor and Kagan joined. Gorsuch filed an opinion concurring in judgment, in which Ginsburg joined. Roberts dissented, in which Thomas Alito Kavanaugh joined. Kavanaugh filed a dissenting opinion, in which Thomas joined. So this is a 5-4 opinion, but it's not a clean 5-4. There wasn't 5 votes for one majority opinion. So the Cougar Den wins, but the rationale for the reason they won is split 3-2. But they don't have to pay their tax, so for the moment, they don't really care that much. So that is the case of the state of Washington versus Cougar Den. So yeah, according to the U.S. Supreme Court, when the United States government agreed to this treaty with this Indian tribe in 1855, as part of that treaty, they gave them the right to use the public highways and included the right to take goods for trade, which would have been as typical in 1855 as it is now. Of course, the nature of trade has changed somewhat, but that's neither here nor there. So as a result of that, it means that the Indian tribe does not have to pay these taxes, and they do not owe the state of Washington $3.6 million. So nice benefit if you can get it, but only available to the Indian tribes because of the specific language of the treaty. This also brings to mind the still pending question of whether or not half of Oklahoma is in Oklahoma or not, which the United States Supreme Court did not resolve this term. There too, that's going to be an issue of language, and there too, of course, Congress could fix the issue. The United States law is fairly clear that the United States Congress can, of course, just abrogate the treaty or change it at any time. So, if the United States federal government's really irritated by this, they could always pass a law saying that they changed their mind. But given the current political dynamics of Congress, I would not expect that to happen. So whether or not it's necessary in this case for $3.6 million, or perhaps whether or not it's necessary in the much more serious case of saving half the state of Oklahoma, I would not expect congressional action because of the natural politics when it comes to Native American populations. But for now, my friends, this is all. I hope you're well, and until later, cheers and goodbye.